Ladies and gentlemen, welcome aboard the Pilot Lawyer Podcast. Thank you for your attention while this important legal information is reviewed. What you hear should not replace consultation with an attorney and should not be considered advice for your situation. On behalf of the Pilot Lawyer and your entire crew, it's our pleasure to have you aboard.
Welcome, aviators, to the Pilot Lawyer Podcast with us, the Ison brothers at the Ison Law Firm. We're here to help pilots and those who want to become pilots navigate the FAA medical certification process. Around the office, we say, if you don't laugh, you cry. For the next 30 minutes, we hope to bring you the lighter side of what can otherwise be a frustrating process. So whether you're laughing at us or with us, join us, brothers, as we discuss the fascinating world of FAA medical certification. Today's topic is going to be petitioning the NTSB for review of the FAA medical certificate denial. What does it mean? How does it look? What does it smell like? What do you got to do it?
If it smells bad,
how is it best barbecued? All the
low and
ins
slow.
ups.
I can tell you the answer to that one.
Well, it will be low and slow. I'll tell you that. But there will come a certain point in time when you're going to want to take that baby off the grill
and throw it in the trash.
Yeah.
So you've got it.
So let's. Are we going to vamp? Are we going to vamp it all, or just going to get straight into it? Anthony wants to get straight into it. So
Cook straight to the guano.
There's
gentlemen.
not going to be any kind of fun, intermodal conversation.
Nothing fun about it.
You won't glean anything into our personal lives in this episode.
No, other than we're fat, we like to eat, and our wives don't like us.
And we might be in a moment of low blood sugar, it sounds like.
I think our wives like us.
We're leading up to a lunch, and I think it's gonna show. You're gonna be able to see that.
It's not going to be a show because of that.
Well, you'll be able to see it.
Just get to the content.
Even though this is a podcast, you will see it. Anyhow, so you've been denied.
What kind of denial did you get? What kind of denial do you require?
That is an excellent question. Oh, I applied and then I got this denial letter 2 weeks later in the mail. Well, that probably is.
Let's take it back even further.
Oh.
You're diagnosed with something.
You were born.
Pretty much. You were diagnosed with something. Now, what you're diagnosed with will depend on what kind of denial you're capable of getting and how you get it.
Is it a specifically disqualifying condition?
So the Code of Federal Regulations, the little scrap of paper where they write down their thoughts, their musings and rules on medical certification criteria. Within those rules,
it's Part 67.
Part 67 of the Code of Federal Regulations, the body of regulations, there are specifically reference conditions in the regulations. So the regulations identify, if you have, diabetes mellitus, or if you have a pacemaker, we're not giving you a medical. You do not. Good day, sir. You're done. That's what the regulation says. And so in that case, the FAA doesn't have to do a lot of digging and testing. They can just say, looks like your records say you have a pacemaker. Denied.
Is that a Seinfeld reference?
Yeah. Okay. Why do you have to give credit there? Why you got to extrapolate all of my little references?
Because I got.
Because they're not original, sir.
I'm pulling it out for time. Okay.
Okay.
Whatever.
So that being said, so you got these final denials that don't require a lot of
back and forth.
Yeah. Malice aforethought, right? It's just, we've got enough records here to support this denial. We asked for your records.
You apply for the medical. On this medical, you put down, hey, listen, I have a history of type
pacemaker. I have a pacemaker.
Okay, I have a pacemaker, right? So you answered yes to 18G, I think it is. Yeah. Heart trouble. You tell them that you have a history of pacemaker. Your AME says, hey, maybe give me the records so I can send them to the FAA. Or maybe the FAA comes back and says, hey, send us the records related to this pacemaker implementation. You send them the records. And then the next thing you know, bam, you got a letter, it's final denial. And they're denying you under, 67, 110, 210, 310. And they're saying that you have a history of, maybe it was a coronary artery disease that's required treatment because of this.
Well, it specifically identifies pacemaker.
And that one too. Yeah. All right. So now what do you do?
So
do you request reconsideration of that denial?
You could in theory, but you would. So for a specifically disqualifying condition, this is where it gets a little complicated.
This is where everyone needs to pay attention.
Yeah, this is
they're
where
going to
it's
screw this up,
Yeah.
and they're going to aggravate everyone at the FAA, the NTSB, and then we'll have
If
to get
you
involved.
legitimately have the reason the pacemaker is a good example is because you either have a pacemaker or you don't.
Sure. Okay.
So if you legitimately have a pacemaker,
You're going to know.
you legitimately have one of these disqualifying conditions, you can't go to the NTSB.
There's no point.
There's no point because if you're going to the NTSB, your objective is to establish by a preponderance of the evidence that I do not have the condition which is alleged
And the
that I
denial
have,
letter.
right? So they are saying I have a pacemaker. I am saying I do not have a pacemaker.
Throw open your shirt and show them your chest. There's no scars whatsoever.
Man,
There's no
please keep
pacemaker.
your shirt.
Sure. Since this is predominantly...
Christopher, you keep your shirt on
yeah,
too.
yeah. You don't want to see my chest. Anyhow,
We don't need another celery clip.
the point is you either have it or you don't have it. If you have it on a specifically disqualifying condition, and if you have it and you legitimately have it, well, you got no business going to the NTSB.
Yeah.
You got no business.
You need a special issue.
You're going to need a special. And the NTSB is not in 100,000 million years from now until the time that this planet blows up because the sun implodes.
Christopher took his shirt off.
And I took my shirt off, is going to care or have anything to do with telling the FAA, hey, give this guy a special issuance. That's not their jurisdiction. That's not their job. They don't care. And they'll throw you out of there quicker than a bum getting thrown out of,
Not Atlanta.
well, wherever bums get thrown out of.
So there's that. Correct. So what is a special issuance? Well, a special issuance is
That's between you and the FAA.
Yeah, that's a waiver at the federal air surgeon's discretion, right? Hey, this guy does have a pacemaker. This lady does have a pacemaker. But I think I can give them a waiver because
I
they
can
meet
mitigate.
certain criteria, and I feel like, yeah, okay. The regulation says he's got this problem, but I think he's going to be okay, and we'll monitor him.
We
We'll
can
monitor.
mitigate against the risk of any kind of recurrent symptoms that might lead to a sudden incapacitating event while in flight. You know, we think that despite the fact that this guy's got a pacemaker or this lady has a pacemaker, that we can mitigate against these risks, and they're not going to be any greater threat to aviation safety than the general population. Right?
Correct.
Because there's stability. There's stability of condition. It's not like this guy or gal's pacemakers firing off every 10 seconds and, you know.
I mean, that didn't get into, does not making this podcast about pacemakers, but you get into like defibrillators.
It's the
having
idea,
them
it's the
turned
concept.
on.
You're going to
There are
have
some
to
things that-
extrapolate here on this podcast, okay? There's going to have to be a little bit of thought on your end today.
Yeah.
To say, well, maybe I've got a
Absolutely.
specifically disqualifying condition.
Yeah. There's going to be probably the most litigated, specifically disqualifying condition is substance dependence because it's a little loosey-goosey. Do I have substance dependence or do I not? Do I meet these weird, random, subjective criteria
Well, I think that's where really any specifically disqualifying condition, I think the pacemaker was a good example because it's like, you know, you either have it or you don't have it. But there's going to be other things
Maybe
that
I don't
are
have it.
specifically disqualifying that maybe like bipolar disorder.
Yeah.
You know, okay, I was diagnosed with it, but you know,
Do I really
how do
have
I
it?
know? Do I really have it? Was it a legitimate diagnosis?
Probably the psychiatric.
I was in a car accident, went into the hospital, and I was aggravated, and and the
maybe
doctor said I got bipolar disorder.
A good
'cause I
one
was-
is not
is
to
that
talk-
legitimate?
No. Transient loss of nervous control system without satisfactory explanation of cause. That's a specifically disqualifying condition. So that's a situation like, well,
Why did you lose consciousness?
why did I have a seizure? Or was there a reasonable explanation of cause? Do I have epilepsy, which is one of the other criteria, right? So that can be litigated. Some of these things are a little bit more loosey-goosey, right? And you have to have some evidence. You can't just say, oh, yeah, I've got 5,000 pages of people saying I have. You're going to have some evidence to say, well, I disagree with this determination because the standard at the NTSB is as follows. Go ahead.
It's preponderance of the evidence.
So what is the preponderance of the evidence?
And it's basically 50% plus a feather in your favor.
So they got the scales of justice.
And they're all, everyone's throwing down their cards, right? Here's my facts. Here's my facts. Here's my facts. And you got the scales of justice, and the FAA's throwing down their facts. You're throwing down your facts on your side of the scale. And, by God, the scales are still evenly waved.
Oh, there's something falling from the sky. sky.
Evenly weighed.
There's something falling from the sky. What is
Look,
it?
here comes a feather.
A feather. A
And
feather
it lands on your side, tilts in your favor. By
But
God,
that
you
is-
just
How
won.
often does that happen?
Yeah.
Not often, but that's the problem. You have the feather burden in these cases. The FAA doesn't have to come in there and justify their position so much as you have to go in there and say, hey, FAA got this wrong. You have to prove that the FAA erred in their decision.
The problem there is that, well, the FAA is made up of a bunch of experts. You know, they're on the payroll, for crying out loud. These are the people that are making the rules, interpreting the rules, and they're looking at your files as they interpret their rules and their policies. So when they say, hey, you're denied because of this, guess what? They've probably got somebody that's already looked at it, that's got the credentials. They're going to come in and say the same thing, which means that you have got to go and you've got to get somebody of equal weight, i.e. an expert that's appropriately credentialed that can come in and say, hey, I've looked at everything the FAA's looked at. I'm seeing what they're seeing. It's an apples to apples comparison. It's not just an apple to apple. It's a green apple to green apple of the same vintage variety. Came off the same tree, right?
Correct.
And I don't see this as the FAA sees it, and here's why. And then it becomes a battle of the experts.
Correct.
Right? Who's the more credible, persuasive, in-depth, logical,
in-depth
and persuasive expert? That's what the case law requires. For the judge to then say, well, I find this expert to be more, logical, in-depth, and credible, blah, blah, blah. And if he finds it to be yours, hey, guess what? Your feather just landed on your scale, and perhaps you win. If not, well, that denial is staying in place.
That's right. Now, just because you maybe lose at the NTSB doesn't mean you couldn't still get a special issuance on that, right? So those are sort of simultaneous, not simultaneous. They could be bifurcated concerns, right? I've lost at the NTSB. I've got this condition, but maybe they still consider me for a special issuance.
Maybe.
So sometimes it might make sense to say, hey, I'm not going to win at the NTSB. So maybe I'll just pursue the special issuance and maybe they'll be more reasonable there and I'll save some money on experts and so on and so forth. Now, that's for a final denial on a specifically disqualifying condition.
Now it's about to get fun.
Now it's getting crazy. Okay,
Now,
but let's consider that cockpit conundrum today. You ready?
Welcome, aviators, to the Pilot Lawyer Podcast.
We call this one. Let's see. Which one do I want to do?
Which one's relevant? How about we ask that question?
None of them are.
None of them are. That's the whole point of them. Keep you on your toes. Call this one VA disability. VA disability. A 37-year-old veteran applies for a third-class medical certificate. In MedExpress, he checks yes to 18Y, medical disability benefits. In the explanation box, he writes, VA disability benefits for service-connected conditions, all stable, no active treatment. He checks no to every other 18 series question. No to mental health, no to neurological conditions.
Yep.
No to high blood pressure and so on.
18X. Did he answer yes to 18X?
No, it just says no to 18X. It just says yes to 18Y. The AME issues the medical condition based on a clean physical, or the medical certificate based on a clean medical exam.
Well, he messed up too.
Pilot gets back in the left seat. He's in the left seat. 6 months later, the FAA sends a letter of investigation.
Well, they've messed up too.
We're initiating an investigation into potential falsification of your medical application for failure to do what? Let's talk about that. What would it be potential for investigation there? Because I'll tell you, this pilot was shocked when he saw this letter. He pulled the letter out of his mailbox, ripped the mailbox from the ground, threw it through a stained glass window at a local church, and just absolutely lost his mind. Kicked a few kittens on the way down to the church.
a hate crime.
The kids were based on principle, though.
Now he's got something like 18W to report.
Yeah.
So here's the problem. He has medical conditions for which he receives VA benefits that weren't also appropriately reported at the other items in Section 18.
Explain it.
So let's say...
Don't tell us. Explain it.
Let's say, for the sake of brevity, and clarity. This individual is receiving a sole VA disability benefit for PTSD.
Post-traumatic stress disorder.
Not receiving any other benefits for any other conditions. He's 70% rated for PTSD, and that's it in total. And he didn't apply for any other conditions that he was not given a service connection for.
He applied only for PTSD, got PTSD.
That's it.
Asked and answered.
Got it. He applied for it. He got what he wanted. But he didn't put PTSD at 18M.
What's 18M?
Now, 18M asks, have you ever in your life been diagnosed with, previously had, or presently have a mental health condition? And that's where the FAA would expect an individual with a history of PTSD to report, or answer yes to it, report PTSD.
That there's redundancy built into the application?
Yes, you may very well be answering multiple questions and putting down the same condition in response to those multiple affirmative responses in Section 18. So just because you put it down in one section doesn't necessarily mean you're done.
Now, would you say that should be grounds for a falsification action?
Well, I think that's where there becomes a question, because in these falsification cases, the FAA has the burden of proof, right? So now they have to get the feather dropping on their side, but there's three elements they got to prove. That there was a false statement in relation to a material question, and that false statement was made with knowledge of its falsity. The problem here is that the case law pretty much establishes that every question on the 8500, the medical application, is going to be material because it has a natural tendency to influence the administrator's decision to issue a certificate. So they've pretty much won that one through case law. Then the question is, well, was there a false statement? Well, do you have a mental health condition? Have you ever been diagnosed with one? Do you previously have one? Did you have one now? Well, you're getting VA benefits for PTSD. So, I think it's kind of difficult to make an argument that you didn't have it when you're receiving a benefit for. So you should probably say, yeah, that was a false statement. Now the question is, well, did you knowingly make a false statement?
Well, you were able to put it down in 18Y.
Well, that's the problem. You didn't really. You just you accurately answered the question, are you receiving VA or medical disability benefits? And you said, yes, I'm getting VA benefits, but you didn't answer 18M appropriately.
Has your FAA medical certificate been denied? Are you concerned you may not be able to get a medical certificate from the FAA? Are you at risk for FAA action for failing to report your medical history appropriately? Call the pilot lawyer at 1-855-FAA-1215 to discuss your options for getting the FAA to issue your medical certificate and get you flying. We are happy to evaluate your case and discuss with you a plan for presenting your case to the AME or the FAA. Aviation law is all we do, nothing else.
So the problem here is that you probably meet all three of those prongs. You made a false statement in relation to a material question, and you made it with knowledge of falsity. The problem for the FAA, though, and I think this is where an affirmative defense would come into play, is that had they done their job and did an information request for your VA disability award rating decision letter and said, hey,
or had the AME done,
done his job and said, well, okay, so you got VA benefits. What are you getting them for?
Give me your VA decision rating sheet.
Oh, yeah, we need to amend your answer of no. Amend.
That's what you said.
It's
like an omen.
Hey, how about you sit over there and just let me do my thing? Okay? I don't sit over here.
Sound like my wife.
I don't sit over here and get involved in your little speeches and your little,
You fell asleep during the last
tribes.
Yeah. Well, hey,
somebody's got to keep
say
the
something
content
interesting
flowing.
next time I won't fall asleep. Point is this. There is, I think, probably some knowledge out there that had the FAA or the AME done a little due diligence, come back to you and said, hey, what are these underlying conditions for which you receive said benefits? They would have seen this history such that they could have then did an information request related to it and did what they needed to do.
I love it.
It's a difficult case, but it is a case that has something to discuss.
It's got some legs.
So there's your cockpit conundrum.
Now, let me say this much. Let me give you another little loop-de-loop. I got tinnitus, rated for tinnitus. Tinnitus wasn't on the medical application. What do I...
Goes at 18X.
What's 18X?
Other illness, disability, or surgery.
So if I have a condition that's not specifically referenced potentially on the medical application, at a minimum, I am obligated to report it at question 18X unless there's some other appropriate box elsewhere.
Yeah, pretty much anything not referenced in the other boxes goes at 18X. Even if it's a fever, if it's a cold, if it's a sore on your upper lip, everything is going at 18X. Even sleep apnea. They want sleep apnea at 18X. And they'll revoke people for not reporting sleep apnea. Yet, for something as big a deal as sleep apnea, something that is disqualifying at the federal air surgeon's discretion, which is, we're going to segue back.
That's a good segue.
They'll want you to put it down because, it's another illness. So
the cockpit conundrum has been answered, but with a nice segue into the other type of appealable letter. So we spoke about specifically disqualifying conditions. Now there are non-specifically disqualifying conditions. So
let's take anxiety for
anxiety is a
example.
great one, or sleep apnea.
No, anxiety is better.
Okay, it's even better. It's even better to have anxiety
because sleep apnea, they're going to say special issuance, and you got it or you don't got it. Whereas anxiety,
okay,
that's up for debate.
Fine. We don't plan these podcasts at all. It's purely as it comes.
That's
how life is, as it comes. Sometimes it
coming to you on the street in Atlanta.
Listen to the last episode. You'll get all these Atlanta references. That being said, they're not all real fine Southern gentlemen in Atlanta. Let me just put it that way. They're not, unless that's a gentlemanly thing to do. I do it right here in the street. We saw a man wiping his butt in the streets in Atlanta. Okay.
You got it out.
He pulled it out. It was awkward and weird. And we saw things we should have never seen at no fault of our own.
In the middle of the street.
Trying to go into the courthouse, and there's this man. Yeah.
On the sidewalk.
He's wiping with some toilet paper.
From
it wasn't even toilet paper. It was like newspaper. I'm telling people it was newspaper.
It was that?
I didn't even. Yeah.
$100 bills.
Probably.
Could have been his hand for all we know.
Like the old times.
So
surely they were using.
It wasn't
their
an
hand.
acorn.
Yeah.
All right.
Ooh.
Here's the thing. If you have a denial
I'd
letter,
rather just talk about those types of things.
if you have a denial letter,
So with the listener,
and it's based on a discretionary disqualifying condition.
I don't know what the word discretion. I'm being facetious. What's the word discretionary
I'm
mean?
about to explain it
me.
to you all. So you have a medical condition that has been appropriately disclosed. The FAA has asked for records related to that. You have provided them with the records, and they've come back and they've denied you. At that point, the question is, well, can I just appeal that directly to the NTSB for review of that denial, or do I have to go through a process? And so that's where this whole question of, well, is it a specifically disqualifying condition, or is it a condition that's disqualifying at the discretion of the federal air surgeon? Anxiety is one of those conditions that's not specifically disqualifying. You won't see the word anxiety referenced by name in the regulations as being disqualifying. As such, it becomes a condition that's found in a catch-all of the regulation that says, based on the case history and qualified medical judgment, that the person has no mental neurosis, personality disorder, or other mental condition that the federal air surgeon would find to essentially make the person unsafe to operate an aircraft. So you tell them that you got anxiety on your application. They come back. They ask for records. You send them the records. They come back with a letter saying, hey, guess what? You're denied for anxiety under 67107C, 207C, and 307C. What do you do at that point, Anthony? Can you just go straight to the NTSB?
No.
Why not?
You have to have reconsideration by the
it's
federal,
not a
specifically disqualifying.
No, it's not a what. It's not a what. It's not a
final denial.
There you go.
I was saying the same thing. It's just
Well, you didn't say the right word. Okay. We play hide the ball here. Anyhow, you didn't receive a final denial. Only final denials are petitionable to the NTSB for review.
correct. How do you get a final denial in that situation?
You have to request reconsideration.
Perfect. Now, let me ask you this question.
And when you request reconsideration, who are you requesting reconsideration to?
The federal air surgeon.
Well,
where has it been this whole time?
Yeah, exactly. Who have I been talking to?
You've been talking to the manager. You've been talking to the AMCD, which is Oklahoma City. It's like the lower level thing, right? So you're not going, your file's not getting sent up to DC, which is where the federal air surgeon is, until,
You request
Oklahoma City's
reconsideration?
taking a look-see.
So how long does it take Oklahoma City?
It could take several months.
How long does it take Federal Air?
It could take several years.
Okay.
Right? I mean, I'm not going to sugarcoat it anymore. It could take several years in certain cases. Now, is it going to take several years? Probably not. But it could.
So is it important that certain information is available to the FAA when they look at this?
If you say, hey, I just want reconsideration, Federal Air Surgeon can come along and just probably just rubber stamp things.
Now, here's an interesting question. Let's say...
I'll give you an interesting answer.
Let's say you do this. You tell them on your application you got anxiety, right? They come back. They do an information request. Okay, get us a detailed clinical progress note. Go get us your treatment records. Send them to us. You send them all that. You know, the detailed clinical progress note says, yeah, this guy has anxiety, but he's doing well now. There's no issue here. The treatment records show that he has anxiety, but he's not on any medication. No need for treatment. And they come back with a denial for anxiety.
Yeah.
And then you say, well, what? WTF, Mike? Right?
Hey, Mike.
Hey, Mike.
Is this because I'm from Australia?
Yeah. This is discrimination.
Pretty good.
You request reconsideration. Goes up to DC now, right? Takes forever and a day for them to come back and say, hey, denied. Final denial. Is that what's going to happen? Final denial?
At that point, yes.
Now, should you at some point have sent them a psychiatric evaluation from a
I would say so.
psychiatrist?
Now, there are things you can do, right? If you've got to, even before you get that initial denial, there are things that you can be doing to prep your file to try and help build your case. Because here's what the big point is. When you go to the NTSB, the main piece of evidence here is going to be your airman medical file. Everything that's gone into the file, that's what the FAA is utilizing to justify their denial of your application. And so that file is what's going to be litigated at the NTSB, which is to say, hey, this is what the FAA had in front of them. And here's why, it was a wrong decision for them to say he was, this person was deniable.
So when we look at something like anxiety or some other type of discretionary condition that is disqualifying at the Federal Air Surgeon's, whim, we're looking at case history, inappropriate qualified medical judgment. So if you've had your case history given to the FAA, i.e. your treatment records, right? Maybe a detailed clinical progress note, but then you have the appropriate qualified medical judgment, which in this case might be someone like a HIM psychiatrist, opining that I've looked at all this stuff. This person seems fine to me. I don't see an aeromedically significant situation because of this anxiety history. And then yet the FAA still denies you. It's only strengthened your argument when you go to the NTSB to say that the FAA's decision to deny you on this discretionary issue was arbitrary and capricious because appropriate qualified medical judgment says the opposite. So it's important as you go through these things to try and have some downrange perspective.
Correct. Now, what I think we're leaving out here is what can one expect? What is the NTSB? What happens in that process?
So you file a petition and basically you say, hey,
now
listen,
you got a certain period of time. Once you get that
final denial,
you have a certain period of
60
time.
60 days from the date of the letter, not from the date that you receive it. From the date of the letter. Okay. So, hey, you might receive that letter 20 days after it's dated.
Yeah. You got to get that
crazy.
Within 60 days.
So within 60 days of the date of the letter.
Do it before 60 days.
Yeah,
Okay.
Don't wait
Do
on
me
the
a favor.
60th day.
Do me a favor.
And don't call us on the 59th day either because that's a little rough. We'll still answer your call. But regardless, you'll have to file a petition with the NTSB and you'll have to essentially dispute the allegation that this history of anxiety for purposes of this example is aeromedically significant. There's a whole process of how to fill out make a petition, how to
notice
file,
pleading,
how to file the petition, et cetera, et cetera. But once you file the petition with the NTSB, then the FAA will eventually file an answer to the petition. The NTSB will assign an administrative law judge to oversee and handle the hearing of that petition, and eventually a trial will be set, et cetera, et cetera. You'll engage in discovery with the FAA, and the FAA will engage in discovery with you. That means they could be sending you interrogatories, requests for production, requests for admissions. You could be doing the same to the FAA. They could be setting the deposition of you as the petitioner or any of your listed witnesses. depending upon who you're putting down in your initial disclosures or in your discovery responses. At some point, the judge is going to say, hey, listen, you guys are going to have to file your expert disclosures. And in a lot of these medical cases, you're going to need to have an expert, which means you're going to have to break off a chunk of change to hire an expert. Then you're going to have expert reports written, at which point parties might be taking depositions of those experts. Just, depends on a case-by-case basis. Eventually, there'll be a hearing date set by the judge, and you'll have to go have a trial. And the airman medical file will generally be kind of the primary exhibit, but you'll also need to have your expert available to testify. You may need to testify. Any other witnesses that you have that might be relevant to the issue at hand will have to testify. The FAA will put on their witnesses. It's a whole trial.
It's just a whole trial.
It's a whole trial, my God. That's kind of it in a nutshell. And the idea is that you're trying to prove that the FAA erroneously denied your application. That was a arbitrary and capricious denial. That based on the information they had available to them at the time of the denial, it was not appropriate, such that you should be entitled to an unrestricted medical certificate. And if at any point in time during that trial or that hearing or process, you try to get the judge to tell the FAA that they should give you a special issuance, everyone will lose their mind. Because that's not the jurisdiction of the NTSB. The NTSB... Well,
give me an example of losing your mind.
I mean, they're going to say, well, listen, Mr. Ison, the case law says that the NTSB has no jurisdiction to determine whether a special issuance is warranted in this situation. Yeah, and the people in the gallery clap. So the people clapping will be that from the FAA. Yep, there's the FAA.
And this will be our client.
No, is there a crying one? Yeah. So the NTSB is not really a place where you.
But you could ask you could have asked for reconsideration and gotten a special issuance.
Now,
perhaps
while you're in litigation, that doesn't preclude the fact that you might be able to work out a settlement with the FAA that would for special issuance or some type of more equitable outcome than just a wholesale. Hey, you're screwed. You're denied. Go pound sand.
And all this boils down to one point, self-serving point that people hate to hear us say, including those doctors out there.
This is a legal process.
Yeah. Everything that goes into the file, is later. It's essentially evidence, right? It's like, it's like a police officer with a brown paper bag at the crime scene, bagging up, collecting evidence. Yeah, I'm I'm gonna put this bloody glove in this bag. Yeah, that goes. And then I'm gonna take all the stuff out of this brown bag when I get down to the police station and see if there's something I can charge this person with, right? So it's just a crazy profession, crazy life, and if you want a medical, give us a call.
It's not a medical process.
Right? Yeah,
nobody cares about your medical.
Here's the difference.
Condition.
Here's the difference.
It's only if your medical condition can conform to legal standards.
Let me highlight this point. You go to your AME. The AME says this guy looks great. This guy looks great. Well, how can the AME say that if the FAA deny it? If it were a medical process, the AME wouldn't be saying.
It would be the final word.
I'll challenge you. I think I'm going to challenge. I think if it was a medical process and you walked in there and had a medical condition that the AME has discovered, they're not going to go, oh, hey, go down to the pharmacy and fill this prescription and treat yourself. No, they're going to send you to somebody else. They don't care.
That's it. They don't care.
Well,
They don't care about you or the donkey you rode in on. So, all right. So that pretty much wraps up the whole thought process here on the NTSB. And is it a worthwhile endeavor to go to the NTSB?
Maybe it is.
It depends. It really depends. There's going to be times when you have conditions that you shouldn't be getting anywhere near the NTSB. You're just going to be wasting your time. Really, you will waste your time going to the NTSB thinking that, oh, well, I'll appeal this to the NTSB. Well, you got no business being there because the condition is specifically disqualifying.
You shouldn't be there. You don't want to be there. It's going to cost.
They don't want you there.
It's going to cost to be there.
I mean, with all due respect, you're just in the wrong.
You're in the wrong form. It's like saying, "Hey, I want to take my kids to Chuck E. Cheese, But then you take your kids to Shoney's, right? Or you take your kids to some great...
Shoney's even around anymore?
It should be.
No.
Let me give a better example. I'm taking my kids to the toy store. I want to take my kids to the toy, but I take them to Home Depot, right? It's like, well, I'm not going to get... I'm sure they could they could find a toy there somewhere. I guarantee they'd find... But, a blind pig finds an acorn every once in a while. So that's it.
Yeah.
Wrapping it up.
I think it gets the point across. If you have questions,
give
us a call.
If you have the questions. All right. You've squandered another 35 plus minutes listening to another episode of the Pilot Lawyer Podcast. And even though the FCC allows these musings to continue into the ether, we are the Ison brothers at the Ison Law Firm, wishing you a good day and good health.
This is thepodcastfactory.com.